Good evening, my name is Jaiza Page, and I am the chair of our Housing Committee. The intention of this public hearing is to review the proposed legislation pertaining to Section 450907 of the Columbus City Code, which is currently entitled Retaliatory Eviction. This proposed ordinance is intended to clarify the retaliatory eviction law for the City of Columbus and to modify the title to Retaliatory Action. It is necessary to update the language in order to protect tenants who make a good faith complaint regarding housing, building, health, or other code violations to a government authority or to a person in control of their rental property where the tenant resides. Nearly 19,000 evictions are filed each year, giving Franklin County Municipal Court one of the highest volume of eviction processings in the state. For the past 2 years, I have been working with community partners to dissect some of the underlying causes of the high eviction rate in Franklin County, many of which who are with us this evening. We have the Legal Aid Society of Columbus, the Columbus City Attorney's Office, Code Enforcement. We also have individuals from the Women's Commission under First Lady Shannon Ginther and the Columbus Apartment Association. Initially, Council joined forces with one of our other partners, Franklin County Commissioner Marilyn Brown, and the Ohio State University's John Glenn College of Public Affairs to announce the commission of an eviction study. The goal of the study was to research the causes of eviction, and that was done through interviews with both landlords and tenants, and also to create policy recommendations that can positively change the eviction outcomes here in Franklin County and the City of Columbus. As a result of the study, we determined that 41% of all evictions filed in 2016 were located in just a few zip codes: 43204, 43224, 43228, 43229, 43213, and 43232. Throughout the year, I have also worked with advocates, again, such as the Legal Aid Society, to host a number of successful eviction prevention workshops. Again, the Columbus Women's Commission and the Columbus Apartment Association, we appreciate your support as well throughout these ongoing efforts. In 2017, the City of Columbus and Franklin County allocated more than $11.3 million in emergency service money, in part to service emergency homeless shelters. However, City Council decided that we wanted to do more. City agencies and constituents have expressed to City Council that the existing retaliatory eviction law is outdated and difficult to enforce due to a lack of definitions, as well as to a lack of burden shifting scheme, which will provide guidance to the city, tenants, landlords, and the court. Therefore, my team, along with the City Attorney's Office, dove into updating the current language, and I am truly satisfied with this, and I believe it's a great start. Now I would like to turn it over to our first speaker, Katarina Carrick, Assistant City Attorney. Thank you.
Thank you, Councilmember Page. Katarina Carrick here on behalf of Columbus City Attorney's Office. Just as full disclosure, I have been involved. I'm sorry? Can you hear me now? Okay.
Before you continue, I would like to welcome my colleagues, Councilmember Emmanuel Remy, as well as Councilmember Mitchell Brown. Thank you.
Thank you. As full disclosure, in addition to being with the Columbus City Attorney's Office, I have been involved with the Columbus Women's Commission Eviction Committee, as well as an ad hoc committee that strives to bring together partners with the eviction court and the environmental court in order to address eviction policies. This is just one of the areas that we have looked at. I have limited my scope of participation with the retaliatory eviction revision process to evaluating the validity of the proposed ordinance. And so I will go through a PowerPoint presentation that hopefully will provide the public some clarity as to what the proposed revision entails. Councilmember Page, since you've already talked about the purpose behind the revision, I will skip this part and jump into the background section, which is pertains to the history of our existing code and how we got to where we are today. Other Ohio cities have retaliatory eviction laws. Cincinnati and Cleveland have these laws. Columbus, as you've mentioned, has an existing ordinance as well. It is outdated, and under our existing code, the retaliatory eviction is treated as a criminal charge of first-degree misdemeanor. Since the summer of 2017, Columbus City Attorney's Office has reviewed, I thought it was 26, but just now I learned that it's 40 retaliatory eviction cases, and all of the charges have been denied. We have not filed a single retaliatory eviction case under the existing code section. And this is despite the efforts that have been made to create a robust investigatory process with code enforcement and a thorough review of every single application or packet that comes into our office for retaliatory evictions. Typically, the city brings forth criminal complaints on behalf of city departments. We work closely with code enforcement, and the situation where a landlord and a tenant are in a dispute of this nature about whether retaliation occurred or not is something that is very unique because it's not a situation where the city is representing code enforcement as a department in and using code enforcement as the primary witness in investigating and bringing forward a case. In landlord-tenant retaliatory eviction situations, we have to work closely with the tenant who is making the allegation. So in that sense, it's a unique and challenging situation. Under our current code, it is difficult to prosecute because the burden is on the prosecutor to prove beyond a reasonable doubt that the defendant, the accused, retaliated against the tenant. And just an overview, if I may, of the existing law. The current provision is in 450907. It's titled Retaliatory Eviction, and it says, no owner or person having control of any premises regulated by this code shall institute any action to recover possession of the premises or otherwise willfully cause a tenant to quit a habitation involuntarily, demand an increase in rent from a tenant, decrease services to which a tenant has been entitled, or increase the obligation of a tenant in retaliation against the tenant's good faith complaint or report of conditions in or affecting his dwelling unit, which might reasonably be believed to constitute a violation of a housing, building, health, or other code or ordinance made to a governmental authority or to the owner. And then it also says, provided, however, that this section shall not apply, A, where it is established that the tenant has complained to a governmental authority or to the owner subsequent to the receipt of a written notice to leave the premises, or B, where the rent is increased to reflect the cost of improvements installed in or about the premises other than by the occupant or other costs of operation of the premises. So that is our existing statutory scheme governing our retaliatory evictions under our city code. And the violation is in the violation and penalty section is in 450999, and it says, whoever violates any provision of this housing code is guilty of a misdemeanor of the first degree and shall be fined not more than $1,000 or imprisoned for not more than 180 days or both. The penalty provision is fine, but 450907 has presented a challenge for our office. And so under the proposed change, let me see if I can get this. So the proposed changes to 450907 include the following, and everything that is underlined, and I think you should have a printout of the PowerPoints. The changes are underlined. So 450907A, first of all, the title would be changed. It would no longer be retaliatory eviction, it would be retaliatory action. Retaliatory eviction is a form of retaliatory action, but the scope of this proposed city ordinance is greater than just evictions. It would encompass other retaliatory behavior by the landlord. So I'll just read through this so you get a sense of what the proposed change entails. A, no owner or person having control of any premises regulated by this code shall institute or threaten to institute any action to recover possession of the premises or otherwise cause a tenant to quit habitation involuntarily, demand an increase in rent from a tenant, decrease services to which a tenant has been entitled, increase the obligation of a tenant, or refuse to renew the tenant's lease agreement in retaliation against 1. A tenant's good faith complaint or report of conditions in or affecting his dwelling unit, which might reasonably be believed to constitute a violation of a housing, building, health, or other code or ordinance made to a governmental authority or to the owner or person having control over the premises. Or 2, the tenant joining with other tenants for the purpose of negotiating or dealing collectively with the owner or person having control of the premises on any of the terms and conditions of a rental agreement. As you see, we've with this proposed revision, the threat to institute an action would be deemed retaliatory. Refusing to renew a tenant's lease agreement would be deemed retaliatory, at least initially. And also, some of the other cities have provisions akin to what we have in A2, where if the tenant or the tenants are joining in negotiating or dealing collectively for better terms of their rental agreement, then that would be protected under the city code. And if you turn the page, we go to section B. The city of Columbus bears the initial burden of establishing a prima facie case of retaliatory action. In order to establish a prima facie case, the city must demonstrate the following. 1, the victim is a tenant as defined by Columbus City Code section 4501-405. This is the definition section under our housing code. It's consistent with Ohio state law as well. B2, the tenant has engaged in one of the protected activities under C.C.C. section 4509-07A. The owner or person having control of the premises has engaged in at least one of the following prohibited actions. 1, increasing rent or any other obligation of the tenant. 2, a reduction of any services to the tenant. 3, a warning or a threat of eviction, formal or informal. 4, filing of an eviction proceeding in close temporal proximity to the occurrence of any event referred to in Columbus City Code section 4509-07A. 5, termination or non-renewal of a lease agreement in close temporal proximity to the occurrence of any event referred to in Columbus City Code section 4509-07A. 6, landlord trespassing on the property or forcing entry. 7, shutting off utilities or water services. 7, not accepting rent payment. 8, interfering with the tenant's quiet use and enjoyment of the property. Or 9, prohibiting the right of access to any part of the premises that the tenant is lawfully entitled to use or occupy. And if you look at the next slide, you'll see section C, and this is where the burden shifting comes in. Once the city has established a prima facie case, so initially the burden is on the city to demonstrate that retaliation occurred, or that the provisions under 4509-07B are met, and then the burden was switched to the landlord in the form of a rebuttable presumption that shifts the burden to the owner or person having control over the premises to articulate a legitimate non-retaliatory reason for taking action against the tenant to rebut the presumption to any prosecution brought under Columbus City Code, Section 450907A, that the actions taken by the owner or person having control of the premises were retaliatory, the accused must demonstrate by preponderance of the evidence either of the following. 1, a tenant's violation of the lease agreement between the tenant and the accused, or 2, a reason not related to the tenant's good faith complaint or report to the accused or a governmental authority. If the accused articulates such a reason, the presumption disappears and the city bears the burden of proving that the proffered reason is merely a pretext for unlawful retaliation. So this is the essence of the burden shifting scheme. Initially, the city has to demonstrate that the tenant complained to code enforcement or to the person in control of the property, and that one of the retaliatory actions was taken against the tenant, and that would suffice to at least shift the burden to the landlord to show that they did not act in retaliation, but that they had a non-retaliatory reason for doing what they did. And the way that this provision is written, the way that Section C is written, I think that it allows the landlord to articulate any reason. For example, I'm increasing rent because I've made so many improvements to the property, and this is just reflective of the improvements I've made. Or the tenant has been a problem tenant, it has violated the lease agreement on numerous occasions. And so this burden shifting scheme here would give the landlord an opportunity to articulate why they acted in the way that they did. And once they do that, the city again has the burden to show that the reason that's been offered by the landlord or the person in control of the property, that's just a pretext. Or if the city can't do that, then the fact finder would have no choice but to find that the defendant is not guilty of violating 450907. If you turn to the next slide, and this is the last portion of the proposed ordinance, Section D says, any provision of any lease that conflicts with this section of the code is void and unenforceable. This means that you cannot negotiate away the right to safe, code-compliant housing. And then E says, Columbus City Code Section 450907 is not intended to serve as a basis for a civil claim, a counterclaim, or a defense in an eviction proceeding under Revised Code Chapters 5321 or Revised Code 1923. This is strictly a criminal ordinance, criminal charge that would be brought forth by Columbus City Attorney's Office. This is not intended to interfere with the eviction proceeding. And then under F, penalty, the penalty will stay the same as it is now. I don't think there's been any issues with the penalty itself. If you look at the next slide, or in your printout, in your packet, this is just a little bit of context with the burden shifting scheme. The courts are familiar with the burden shifting scheme, and so they're more likely to uphold the proposed city ordinance and interpret it correctly because it's based on other schemes that are already out there. For example, in the context of eviction hearings where the tenant asserts that retaliation occurred, the burden is initially on the tenant to show that retaliation occurred, and they have to show that by preponderance of the evidence, and then the burden would shift on the landlord to show that they did not act they did not have a retaliatory motive, but rather they were acting had a legitimate justification for bringing the eviction proceeding, and that is not and that reason is not retaliatory. And also, this burden shifting scheme is consistent with the what's in the Fair Housing Act and our case law interpreting that act, with the fair housing claims being subject to a burden shifting scheme, which has been established by the U.S. Supreme Court in McDonnell-Douglas case. Under that standard, a plaintiff must at first present evidence from which a reasonable jury could conclude that there exists a prima facie case of discrimination. If the plaintiff meets the initial burden, then the burden shifts to the defendant to offer evidence of a legitimate non-discriminatory reason for that action. And once that burden is met, the burden shifts back to the plaintiff to show that the proffered reason was a pretext. So this is very similar to what City Council is proposing here with our local retaliatory eviction code. And there's plenty of case law out there interpreting the Fair Housing Act and dealing with the burden shifting scheme that this framework would be familiar to the courts who are looking at the retaliatory eviction provision. And also another consideration under state law is the fact that we have under Ohio Revised Code Chapter 5321 quite a comprehensive landlord-tenant law, state law, and under 532102, there's a provision, it's called retaliatory action by landlord prohibited, and it specifically speaks to the eviction proceeding and provides for certain situations where a tenant would effectively have a defense of retaliatory eviction in that eviction proceeding and would be able to demonstrate retaliation by the landlord. And 532102 says that a landlord may not retaliate against a tenant by increasing the tenant's rent, decreasing services that are due to the tenant, or bringing or threatening to bring an action for possession of the tenant's premises because, one, the tenant has complained to an appropriate governmental agency of a violation of a building, housing, health, safety code that is applicable to the premises, and the violation materially affects the health and safety. Two, the tenant has complained to the landlord of any violation of Section 532104 of the revised code. Three, the tenant joined with other tenants for the purposes of negotiating or dealing collectively with the landlord on any of the terms and conditions of a rental agreement. And so under B, I'm not going to read all that, but it allows the tenant to essentially assert a claim or a counterclaim, a defense, using the retaliatory action scheme that's in our state law, and either stay at the premises or terminate the lease agreement, or get other remedies under state law. And so the reason why I went over this is because what City Council is should be interested in, and I think is interested in, is avoiding potential conflict with state law. And we need to make sure that we're not regulating the eviction proceedings, but rather that we're focused on our interest as a city to ensure that retaliatory actions are properly dealt with as part of a criminal process, and that we are encouraging and protecting tenants who do have substandard housing conditions at their premises, and that we are not letting landlords retaliate against tenants who are communicating with code enforcement and other city agencies. I included another section in your handout, 532103. I'm not going to read that, but it's, I listed it on there because there are certain scenarios in the actual eviction proceeding where, despite the fact that the landlord may have retaliated, the landlord would still be entitled to possession of the premises. And if the tenant didn't pay rent under existing law, if the tenant did not pay rent or is in default of the rent payment, then the landlord is entitled to proceed and get the property back. And so we really don't want to interfere with that process. And if we did, I think that the city would have, could be subject to a challenge. And I think that the way that the proposed ordinance, revision to the ordinance is written, I think we steer clear of a potential conflict with the state statute. And I included some information here on the home rule. There's an analysis that we would use to evaluate whether any of our local ordinance is in violation or is in conflict with a state statute. There's a scheme that's in place. However, I think that the way that the statute is, or proposed ordinance is written, we're steering clear of that potential conflict with the state law. And then just lastly, expected consequences. Practically speaking, as somebody who works in the environmental court and has helped code enforcement establish their current process for investigating retaliatory evictions, I think that what you are likely to see is an increase in retaliatory action criminal charges filed and successfully prosecuted in the environmental court, which would have exclusive jurisdiction to hear these cases. Also, I think the burdens shifting scheme is going to provide guidance to city departments, from code enforcement to health department to city attorney's office to landlords and tenants and the court itself to know how to handle these really unique and delicate situations. Also, the landlords who do retaliate against their tenants for contacting the city about housing conditions, they actually may end up going to jail. If we can bring these cases, I think we will see practical and appropriate results. And the penalty section will stay the same, but I think it's pretty adequate, up to 6 months of jail. This is the maximum penalty that we can have as a municipality, up to $1,000 fine for retaliating, and potentially even have them placed on probation to ensure they don't retaliate against future tenants. And I do think that practically speaking, landlords are more likely to fix code violations at their premises, knowing that we have an ordinance that is comprehensive and has teeth to it, and they may be less likely to evict a tenant because they have code violations inside their rental unit. Thank you.
Thank you, Attorney Carrick. I would also like to thank and acknowledge President Pro Tem Stenziano, who has joined us this evening. Are there any questions or comments from my colleagues? Thank you so much. That was a great presentation and very thorough, and really pointed out the proposed changes to the legislation. And I would also, before we go to Ben Horn, like to thank Attorney Isaac Rinsky, who is with us as well, who is a prosecutor and works in the environmental court, and I know has worked with you as well on this legislation. Attorney Horn, the floor is now yours.
Oh, thank you. Is the PowerPoint working?
Maybe
Oh, okay.
I broke it.
You broke it. Thanks a lot. Well, thank you, City Council. Thank you, Councilmember Page, for the invitation to share some client experiences with the council. I'm the managing attorney of the housing unit at Columbus Legal Aid. We help tenants primarily with tenants who are facing evictions, and we help tenants who are struggling to get their landlords to make repairs or to do exterminations. And as part of this, we've found that some landlords will retaliate against tenants, specifically when the tenants call code enforcement. And so I'd like to look at a few examples of that. Oh, good. Click this one. We find that most tenants, they don't first call code enforcement. It's only after they've repeatedly tried to get their landlord to take care of an issue. Oftentimes, this is just through phone calls, maybe in person when the landlord's picking up the rent. Oftentimes, they text, as we'll see a little bit later in this presentation. A lot of tenants, they call and they say, well, what am I supposed to do when my landlord's not making repairs? And we say, well, you notify them in writing, wait a reasonable amount of time, and then if that doesn't work, you might want to escalate by calling code enforcement. And they thank us for that advice, but they look at us like we're really naive because they are very worried that if they do take that step of calling code, that the landlord's going to retaliate. I think this is tied into the severe shortage of affordable housing in Columbus. There's a desperation for housing, and we hear landlords, well, we've heard tenants report that their landlords have said, if you don't like it, you can just move. Because I just had 3 or 4 calls from tenants that are looking for a place to live. So there's a disincentive. Let me go back there. I want to talk about the retaliation cycle that we see and which this proposed ordinance is going to address very effectively, I believe. So we've got a frustrated tenant, finally calls code. Then the landlord focuses on getting the tenants to vacate, and that's what I'm going to focus on here, some of the methods that we see. If the tenants do vacate, then when code comes back to reinspect, oftentimes they cannot get in because the home is now vacant, and if it's vacant, it's not a housing code violation for the interior violations. And then after the dust settles, we'll see the landlord re-rent the property with those interior code violations still out of compliance. So the tenants and the property both suffer. And we end up with this dilemma for tenants, which we hear every day. Should I stay here? I've got bed bugs, I've got no heat, but at least I have a home. Or I do complain, do I call code, and then risk the trauma and upheaval of a retaliatory eviction, taking my family to a homeless shelter. This is a real dilemma that we see, and a lot of tenants don't complain, and they just endure these conditions. So 2 methods that I'm going to talk about on that landlords use to get tenants to leave. One of them I'm not going to focus on, but frankly, it's just it's a threat that if you call code, I am going to file an eviction against you, and the very filing of an eviction action will hurt your ability to rent again in Columbus in the future. We don't find out about those very often. Another very common method we see is the termination of the month-to-month tenancy. Frankly, in a lot of the lower-income neighborhoods, the landlords only will offer a month-to-month tenancy. And shortly after code inspects, the landlord provides the tenant with a notice terminating the month-to-month tenancy, and the tenant has to leave within 30 or 60 days. And these are no-fault notices. They don't say that the tenant did anything wrong. But it does create a situation where if the tenant doesn't leave, the tenant becomes a holdover tenant and is at risk of being evicted for holding over the lease term. The second method is that the landlord either threatens to evict or does evict on false or fabricated grounds. So I'm going to talk about 3 women whose names have been changed, but they had the gumption to call code enforcement, and we're going to see what happened. So Tammy's the first example. She was a single mother living with an adult daughter. She was staying at the Van Buren shelter, and on May 1st, she moved into a house on the south side. And it had a number of problems, and she moved in May 1st. May 15th, She wrote down, as she should, she wrote down a list of things that she wanted the landlord to repair. And the landlord failed to make the repairs. So on May 28th, she called code enforcement, and on June 6th, code enforcement issued orders to repair. The very next day, we were expecting the landlord to show up with his toolbox to fix things, but instead he showed up with a 30-day notice, terminated a month-to-month tenancy. We got involved with this case. We filed a nuisance abatement complaint. We had a retaliation claim, and the parties negotiated a move-out. But prior to the move-out date, the landlord entered the rental property when Tammy was not home and threw her belongings in the yard. And in terms of how Tammy would have been helped by the revised ordinance, and frankly, the section of it that I'm most excited about is B3.5, which adds termination or non-renewal of a lease agreement as a retaliatory action. A couple other of the 3.6 and 3.8, landlord trespassing on the property and interfering with tenants' quiet use and enjoyment of the property would also come into play, perhaps due to the fact that the landlord entered the property when Tammy was not there and put her belongings in the yard. The second method that we see sometimes is eviction on fabricated grounds. This is oftentimes a situation where we've got a landlord who stops by around the first of the month to pick up the rent and just does not stop by and then evicts for non-payment of rent. Or if the rent is mailed or deposited, the landlord claims that it was not received. Sometimes we see landlords evict for a lease violation regarding an issue that the landlord hadn't cared about previously. Suddenly this pet gerbil that the tenants had for years is now a violation of the lease. It's a problem. So Alicia, this is a tenant we helped. She was renting a home in a hilltop, and she had a landlord that collected the rent by stopping by to pick it up around the first of the month. The landlord was ignoring her repeated requests for repairs. He once texted her and said, "What do you expect? It's the west side." Alicia finally called code enforcement, and on February 26th, code came out, issued an emergency order, also 30-day orders, I believe. So it's February 26th. And we knew Alicia would need to have her landlord stop by and pick up the rent. So we said, you know, hey, you might want to get that rent check ready. So she actually took a picture of her rent check and texted her landlord and said, "Here's the check for March rent if you want to pick it up." And the landlord wrote back, "No thanks, ma'am." So what day is rent due for March? "I'm not taking your rent. You'll receive a 3-day on March 5th. What's the reason? See you in court, stop texting me." So what is the 3-day notice for? Non-payment of rent for March. 3-day notice to vacate. Well, I offered it to you. It's my right not to accept. That's civil laws. So this landlord put all that down in a text, and he was true to his word, and he served Alyssa with a notice to leave premises on March 6th for non-payment of rent, and then filed an eviction on March 21st. Alyssa would be helped by the revised ordinance, specifically B3.7, which adds not accepting rent payment as a prohibited retaliatory action. In this case, the landlord wrote the words, "I'm not taking your rent," in a text as soon as the landlord found out about the fact that the tenant had called code enforcement, and then filed an eviction for non-payment. This would also invoke, I believe, the rebuttable presumption that the filing an eviction within 6 months, which is, I understand now is within a temporal proximity, could also be a retaliatory action. And just one more. I don't want to, take this too far because I have a lot of these, but I'm going to stop with this one. So this is Letitia, and she got both methods here. On October 15th, she called code enforcement, requested inspection. October 23rd, code found violations, issued a notice to the landlord. 6 days later, the landlord found out about it and asked the tenant in a text, "Did you call code enforcement?" Tenant says, "Yes, my roommate did that." And the landlord wrote, well, they wrote up a whole bunch of things on the house. The tenant then goes on to explain that she'd been complaining about black mold and nothing had been done. And the next text she got was, "Your month-to-month lease is being terminated on the 1st. You have 30 days to move out." She said, "You can't do that. We have rights." And the landlord said, "Watch me. You have the right to leave on a month-to-month lease whenever you want, and I have the right to terminate it whenever I want." And she said, "No, they said you was going to try to do this." Who said? Well, it was us that had told her that because we've seen it many times. And this landlord then served her with the 30-day notice terminating the month-to-month tenancy. And then I think the next day gave her a notice to leave the premises. This is alleging non-payment of rent, not only for November, which actually wasn't due yet, but also the prior month, which the tenant had, and she had a receipt. So this was an example of fabricated grounds. I think that this proposed resolution, this proposed revised ordinance will be effective in addressing situations like this that our tenants face, and perhaps will allow tenants who are afraid of retaliation to call code that have been afraid to previously. I think this could result in decreased retaliatory evictions and increased landlord compliance with code officers. So it'll help the properties that our tenants live in, and it'll stabilize our tenants. Thank you.
Thank you, Attorney Horn. Thank you, President Harden, for joining us this evening. Are there any questions from my colleagues? Well, I would like to thank you for your presentation and for giving us those examples. I think it's important to be able to put like real life situations to this and to see how it would help. I do have one question. If you are working with a client who you believe has been evicted or is under threat of eviction, do you have a relationship with the Columbus City Attorney's Office so that you can contact them and let them know what's going on?
Yes, we do. We have a good relationship with the city's own attorneys, with Mr. Rinsky, and we look forward to continuing to work on this issue with the city attorney's office.
Thank you. And our final presentation this evening is Mr. Edgar Dillon. He's with the Department of Development Code Enforcement, and he is a code enforcement specialist. Thank you so much, Mr. Dillon.
Thank you, Council President Harden and council members for allowing me the opportunity to speak today. Thank you, Councilmember Page, for sponsoring this needed legislation, and City Attorney Klein and his office for continued partnership in this. I've worked for code enforcement for over 15 years in various roles. I've been a code enforcement trainee all the way up to my current role as a code enforcement specialist, court liaison between the code enforcement office and the city attorney's office. In those years, as a code officer, I did many interior inspections and have heard many times concerns from residents that they were being retaliated against or could be retaliated against for calling code enforcement. As a code officer, I always did my best to assure them, that there was a code in place, that a landlord was not permitted to do that. And generally speaking, I didn't realize what a problem this was until I took on the role as this liaison between the city attorney's office and code enforcement. And that's when I realized these 40 complaints. I help process those. They all come through my desk to review the packets. The process at the current time is there's a packet that the tenant fills out with questions relating to, how were they retaliated against, and, have they been paying their rent, and what occurred, as well as we add to that packet the violation notices and the various other information for the prosecutor's office to review. And then with the second part of that packet is a questionnaire that we call and discuss with the landlord, what's going on. Generally speaking, those cases that came through, most of the time it's kind of the example that was given where, well, you're not paying your rent. and that happens quite frequently. And a lot of the times that's because the way that the people receive their money and pay it to the landlord, he accepts it, 5-7 days late, but then all of a sudden, because code is involved, now all of a sudden it's a problem that they're not paying it on the first. That happens a good bit of the time. I do believe that this legislation is going to help to protect the tenants from these unfair practices from the landlords. That's really all I have to offer, but I do thank you for the opportunity to speak.
Thank you, Mr. Dillon. And I do have one question. The 40 complaints that you reviewed, what period of time was that in?
That was from 2016, I want to say probably the spring, summer of 2016 until today.
Thank you. Are there any questions or comments? Seeing none, I would like to thank all of our speakers this evening for your testimony and for the additional information that you have provided for us. We will now move to the public speaking portion of this hearing. And our first speaker this evening is Attorney Dimitri Hatzafatinos, representing the Columbus Apartment Association, as well as Steve Gladman, who is coming up with him as well. Thank you both for attending this evening, and again, you have 3 minutes.
Thank you. Thank you. Chairperson Page and members of the Housing Committee, thank you for the opportunity to testify on legislation to update the retaliatory action law of the City of Columbus. My name is Dimitri Hatzafatinos, and I'm an attorney with Willis Law Firm. My practice involves all facets of real estate litigation, including landlord and tenant matters. Today, I'm testifying on behalf of the Columbus Apartment Association. Willis Law Firm is a member of the CAA, and we represent the association's member companies. CAA advocates for the owners and managers of more than 150,000 apartment units. The association's region is the region's leading educator for the multifamily industry. We provide extensive training on fair housing and landlord-tenant laws to ensure compliance. CAA believes that stable homes equal a strong community. So we're very appreciative of Councilmember Page and the City Attorney for considering changes to strengthen the retaliatory action section of the Columbus Code, which the association suggested and supports to help renters maintain their housing. These legislative updates will strengthen a renter's protection without reducing legal remedies available to a property owner. The proposed changes will protect tenants from illegal action that could result in loss of housing. If a rental housing provider attempts to use the eviction process to retaliate, they will be held accountable for their actions under this legislation. Responsible landlords who are members of CAA work hard to keep residents stably housed. From our perspective, evictions are actions of last resort. Tenants lose their housing and that can harm their credit rating, and landlords lose rental income and incur costs. As elected officials and community leaders address the affordable housing shortage in Franklin County, a great deal of attention has been focused on evictions. It's important to put the scope of evictions in context. According to data collected by the Eviction Lab for the past 5 years, only about 4% of Columbus renters are evicted. 50 other U.S. cities have higher eviction rates than Columbus, including Akron, Dayton, Toledo, and Cincinnati. We're optimistic that CAA's housing stability initiatives, along with local government efforts, will lower that percentage. Landlords understand our tenants face financial challenges when they lose a job or must pay a big medical or car bill repair. Landlords routinely work out payment plans so tenants can keep their apartments without falling further into debt. Like you, we believe that a community that makes room for everyone is a better place to live. Columbus Apartment Association members are engaged in stable housing initiatives, including Celebrate One and Community Mediation Services, tenant-landlord mediation. And as announced by Mayor Ginther in October, CAA is partnering with the city to create an emergency eviction prevention fund to assist renters facing a financial emergency that could lead to non-payment of rent. Our association has pledged to raise $100,000 to help fund this pilot and support housing stability. Councilmember Page and the Columbus Apartment Association is pleased to work with you on this prevention initiative. We're supportive of the proposed retaliatory action legislation to strengthen renters' protections as one piece of a comprehensive solution to promote housing stability in Greater Columbus. That concludes my testimony. I'm happy to answer any questions.
Thank you, Attorney Hatzafatinos. Are there any questions? I do have one brief one.
Sure.
If you could just briefly talk about the education efforts that you do or CAA with your members and how you can make them aware of the proposed changes. And also thank you for the suggestions that you made to the proposed legislation. We do believe that it did strengthen it, so thank you.
Thank you. Thank you for allowing us to be part of the process. We routinely offer seminars in areas of eviction, fair housing, and other code compliance of all sorts. I was in a seminar last night for independent owners that lasted about 2 hours from 7 to 9 p.m. And we focus on changes like this that will allow people to better understand the law and stay within the law while trying to operate their businesses in a responsible manner.
Thank you.
Thank you.
Our next speaker this evening is Shante Flowers. Welcome to council, and Ms. Flowers, you have 3 minutes. If you could also let us know any organizations that you're representing, that would be greatly appreciated.
Good evening. Thank you for the invitation. Again, my name is Shante Flowers. Really nice to see each and every one of you. I want to first thank Councilwoman Page, because from the day one, after I presented my issue to the council, you called me, Yolanda, thank you so much, and you was right on top of it. What happened with me, I was renting a townhome in 2005. That was the first time I signed my rent. I had been in there, had multiple issues, communicated with the landlord, slow in repair, consistently just would not respond many times to making those repairs. In June of 2017, I submitted to him a letter, 30-day notice, telling him I'm going to place the rent into escrow, which I did. The rent, every month I paid it, June, July, August, into the rent escrow account. In September, we had a fire. That was one of the issues we were dealing with, was electrical. We had a fire, contacted the landlord on that day. He never responded. Went down to the escrow account thinking I could pull monies out so I can get an electrician to make the repairs so that we could have power restored. They, in turn, contacted code enforcement. Code enforcement contacted the landlord, and within 6 days, I received a letter from the landlord terminating my tenancy there. Because I was month to month after 2006, their response to me was, you don't have to stay, we only have to give you a 30-day notice to vacate, so leave. So from June, July, August, September, October, I consistently paid my money into the rent escrow account. In October, code enforcement did the inspection and cited the landlord with 10 violations. We also had 2 hearings that the landlord, John and Sandy McDonald of Dublin, Ohio, failed to attend, those 2 escrow hearings. In November, they showed up and they just wanted to move forward with the eviction itself, and the eviction at that point was dismissed as being retaliatory. Again, so the money's still building up into the escrow account. Repairs still have not been made, not until November, and that point they were ordered by the court to make those repairs. They didn't start making repairs until December. They completed the repairs in late February, and then on that final date, they sent me another notice to vacate the property within 30 days. As of today's date, I still have not received my rental deposit. And everything they've done, I have to truly say that the frustration that I had was that I received a lot of support from you. I received a lot of support from legal aid. But I have to say, I felt that the landlords were protected by many of the agencies. I even had a community agency tell me I should not have contacted code enforcement. And I just want to know when, tenants typically have firm deadlines. If you don't do this, in 3 days this happens. There's nothing given to a landlord. They're told they have a reasonable amount of time to make the repairs. They sat for 6 months. Every month I paid my rent, and they did nothing. Nothing was done against them or to them. And that's one of the issues that I have with the city and how it pretty much holds the hand of that landlord. You don't give them a slap on the wrist. You kind of rub and massage their hand, and you walk them through the process. I did nothing wrong. I paid my rent on time, and again, nothing was done. They was not held to any kind of standard as to why haven't you made the repairs. And then to add insult to injury, on the last day that they finally did report to court to finalize the repairs, they were ordered to submit receipts for repairs. None of the information that they had anything to do with my property. And that magistrate in particular, that's another thing, and I know my time is up, but as a tenant, we almost felt like we're criminals when we go into the courtroom, and we shouldn't feel that way. The attorney kept calling me defendant, and one of the magistrates corrected him. And I should not feel or be made to feel that I've done something wrong simply for asking for what is right. And I think that when one magistrate may demonstrate how they're going to process and how they're going to facilitate your case, and then the next week you go to a different magistrate and they'll do it totally different. And the standards are just not as concrete and as firm for what is being held against the landlord versus what is being held against the tenant. And I'm very happy to see that you all are still moving forward with this, but please make sure that month-to-month tenants are also protected in this, because otherwise they'll figure, the landlords, oh, we'll get you out, we'll get another tenant in. We'll get another tenant in. You have any questions for me?
Thank you so much for your testimony, Ms. Flowers. President Harden.
Just to comment, just to Ms. Flowers, I just want to say that in no small amount, you played a huge role in us having the space to have these conversations. As council members and as a city, we're having this conversation around affordable housing. But truthfully, it was you coming to council several times with your children and really putting a face to the issue that so many folks were facing. And I just appreciate Councilmember and Chair Page really leaning in and taking up the charge. And we're just grateful. And this is just one step, one piece of the puzzle that Councilmember Page is leading on, and certainly this council is following and supporting.
Thank you so much. I know with the ordinance you talked about month to month, I mentioned that. What about what they had the monies in rent escrow? What is being done with that? Because that's just building up and they're not doing anything. They don't have to do anything, it seems like.
This ordinance is proposed specifically to retaliatory action, but what we can do after the hearing is talk with you a little more to figure out the escrow issue and if there's a way we can address it.
Okay.
And again, thank you so much for sharing your story.
Thank you.
Our next speaker is Mr. Calvin Hairston. Mr. Hairston, welcome to council. Again, you have 3 minutes, and we do have another hearing which begins at 5. Please come up, Mr. Hairston. So I'm going to ask that you stick to the 3 minutes, and thank you for coming to council this evening.
One of the roads that, first and foremost, my name is Calvin Hairston. I live on the east side of Columbus. And I live in a location that's being highly developed. A lot of money being spent, but the one piece that seems to be missing is there's been an effort to move people out. The issue of affordable housing impacts a specific demographic, and the issue of retaliatory action is a big issue. Because there is a demographic of people that really are being pressed out of a neighborhood. Now, landlord-tenant issues is a big issue on the near east side of Columbus. In fact, Stenziano just responded to our community about the seniors. Now, nobody thinks about seniors having issues with landlords, but they do, and I'll give you an example. On the east side of Columbus, CMHA is one of the biggest landlord in the city of Columbus. Now, they just built on Poindexter Village senior housing, and it's 105 units. Now, you would think beautiful, fine people coming in. But there was an issue that came up that nobody thought about. In the lease that they signed with CMHA, once they're given the lease, they're going to automatically sign. But one of the issues that was included in the lease was smoking. Now, you don't think that's a big issue, right? Oh, no. But one of the stipulations in the lease was if you smoke, you could be evicted. Nobody knew it. People just signed it. Blah, 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 blah. Of the 105 units and the people that came back, you would be shocked that the initial people that got the units, less than a year, was kicked out over the issue of smoking. Now, you would think that's not a big issue. Well, once a landlord determines the site to be no smoking. And they have sensors in the unit. The sensor goes off, the security response is documented. You sent a letter, you have violated the rules of your lease. Oh, no, I can do some, no. Now, now this is a fact. If you look at the 105 units just in the senior housing alone, the initial people that took those units, of those 105, I guarantee you over 75% of the tenants that came are gone.
Thank you so much, Mr. Harrison, for sharing that with us. And we can talk more after the hearing is over.
Right.
But thank you, and thank you for your advocacy for seniors on the east side. And our final speaker this evening is Ms. Barbara Clark. Welcome to City Council, Ms. Clark, and we thank you for joining us. You have 3 minutes if you could let us know any organizations that you are representing as well.
Thank you for allowing me to speak. My name is Barbara Clark, and I'm here representing Columbus Early Learning Center, the Black Women's Voters League, also the Columbus Civilian Community Board, and the Mount Vernon Avenue District Improvement Association. So speaking with all of that, that gives me the opportunity and the environment to work with a lot of people with rental issues. I have never, ever been to City Council and had just so much gratitude for what you guys are beginning to do. This legislation would keep a lot of people from being homeless. We have a lot of slumlords, and one of my questions to you would have been, how many of those 40 complaints was the same landlords? We have a lot of slumlords, and those are issues that you put in here that needed to be addressed. So I just want to thank you for coming up with this legislation, and it will truly, truly keep a lot of families housed. Thank you for letting me share.
Thank you so much, Ms. Clark. And for those of you who do not know, Ms. Clark works a lot with seniors on the Near East Side whose housing is substandard and trying to work to keep them in their homes. So again, we thank you. I'd like to thank all of our speakers this evening, Attorney Carrick, Attorney Horn, and Mr. Ed Dillon for your work, and again, for working with us to propose this legislation that we believe will make a difference for the residents of the City of Columbus. Also, again, thank our partners in this work, First Lady Ginther and Shelley Biding with the Women's Commission. We have individuals from Franklin County Commissioner Marilyn Brown's office, as well as the Columbus Apartment Association. Again, this is going to be a team effort, and we all have to work together to address the eviction issues. I thank you for your time, and this concludes our hearing.